One. Yes.
My name is George Ogembo, an advocate of the High Court of Kenya. I have been in private practice for the last 15 years. And in my private practice, I have come to specialize in employment and labor relations law as a very important segment in the society that I thought is an area that needs a lot of research. And I've done a lot of research in the 15 years that I have been in private practice, and out of that particular research, I have come out with various publications. Notable among them is a book on employment law guide for employers, published by Law Africa Limited. And it is on the second edition right now. The second edition is almost out. And in there, I have been able to bring out various aspects of employment and labor relations law that are of great concern to employers and stakeholders as a whole. Today, I would like to tackle a very, very important topic that is troubling a lot of employers and a lot of stakeholders in the employment circle, or the employment law arena, and this is the aspect of termination of employment contract. And because it's a very wide area, I'll be able to have a bias to the redundancy as a form of termination, but I will look at the aspect of termination of employment and which are the critical things that arise when an employer opts to terminate a contract of employment. Now, an employment contract, one of the aspects that needs to be made clear, that an employment contract is by its nature a contract. It is a contract that is entered into by way of offer and acceptance, and also it has provisions inbuilt, provisions for termination when by either party. Now, several issues arise where a termination is undertaken by an employer as opposed to a termination done by an employee. Because a termination done by an employee may opt to terminate an employment contract, and that does not bring serious issues of consideration, because he just basically needs to do a written letter, a written notification to an employer stating that from this particular period, I will no longer be bound by the employment contract. And that becomes effective. And when an employee opts to proceed and communicate that act of, or that decision to terminate the employment contract, the employer has no option but to let the employee exercise that particular right. And therefore, not many legal issues arise with respect to termination. And one of the things that I think is very clear and ought to be made, the employer ought to be aware of, is the fact that they do not have a right to stop an employee from exiting the employment. And what I mean by that is there is no provision that the employer has even to accept the resignation of an employee, or perhaps maybe deny the employee the right to terminate. Now, several issues arise where the termination is to be done on the initiative of an employer. Now, when it's on the initiative of the employer, an employer cannot unilaterally decide, wake up one day and unilaterally decide to say, I am terminating so-and-so, and I'm drafting a letter, and I'm giving him or her, and he's supposed to exit the enterprise. By various amendments of the laws that has happened, it used to happen previously, but by various amendments of the law, notably the amendment that occurred in the year 2007, it brought in a concept of fairness in employment relations. Now, what we mean by fairness is that the law has come in and put various safeguards that an employer has to fulfill or has to comply with before a termination is made or is deemed to be fair. Now, the two major components that were introduced by law is the component of an employer must have a valid and a fair reason to terminate an employment relationship. You cannot terminate an employment relation, even though you have reserved the right to terminate. You cannot terminate by law without having a valid and a fair reason. Now, the concept of valid and a fair reason has been defined in law to mean that these are matters which are genuine. These are matters which are valid and not just merely matters of speculation by the employer. Now, apart from having a valid reason to terminate, because this is a particular reason, these are reasons which the employer must be able to demonstrate to court when called upon to prove whether the reasons were genuine and whether the reasons were a reasonable employer in his or her circumstances would actually take this particular step. Now, the second aspect that the employer has to comply with is that there must be fairness. The employer must be fair. The termination of an employment relationship must be done in a fair manner. What you mean by a fair manner means that an employee must be confronted with the allegations that the employer believes have been committed by the employee in the workplace, and the employee is required to actually answer to those particular allegations, and then the employer proceeds to make a decision considering the response or considering the explanations given by the employee. This is a mandatory requirement. That is what is now known as issuance of a notice to show cause. A notice to show cause is in form of a charge letter where you enumerate very succinctly the reasons or the allegations that you are confronting an employee with in a very clear manner, and then requiring the employee to be able to respond to them is also in a very clear manner. And then once a response is received, the employer makes a decision as to whether they are satisfied with those particular responses, or if they are not satisfied with those particular responses, then a requirement is done that you have to hear the employee before you make a termination decision, or you make a decision, a disciplinary penalty. Now, there's no exception for that, especially where the termination is by way of a dismissal. Now, where the termination of an employment is not by way of dismissal, then there is no that requirement. Now, an employment contract may be terminated by mutual agreement of the parties, or it may be terminated by way of various other means, like attrition, natural attrition, like retirement, and all those kind of stuff. Now, in where the employment contract is terminated by way of mutual termination, there is no requirement for having a valid reason and having or undertaking the process of a fair hearing. Now, moving on now to the concept of redundancy. Redundancy is a form of termination of an employment contract. Actually, redundancy is defined in the Employment Act. Section 2 of the Employment Act actually defines a redundancy as a loss of employment as a result, loss of employment as a result of, just cut it. Redundancy is actually defined in the Employment Act as the loss of employment, occupation or job by involuntary means. When you talk of involuntary means, it means that it is occurring for no fault of an employer or an employee. Loss of employment by involuntary means. Example, if the market conditions become so intolerable to such an extent that an employer is completely unable to keep or to fulfill his terms of employment on a monthly basis by payment of salaries, then he has to take a drastic action by having the employment contract of the employees terminated by way of redundancy. These are acts which the employer cannot avoid in the market, or maybe there are acts which an employer must undertake for them to remain profitable in the market, or for them to remain relevant in the market. So they have to make those particular critical decisions. And so a redundancy can occur as a result of the need or the desire of the employer to be able to just remain relevant in the market, or to react to a certain particular external fact or external factor which has made it completely impossible to operate in that particular environment. So there must be a very genuine and valid reason, that particular instance or that particular circumstance that leads to involuntary termination has to be something that is genuine, has to be something that actually is facing the employer. Now, a redundancy can either occur as a result of a downsizing or a right sizing. And this is where the definition comes now, what we call but a restructuring. If an employer decides to do a restructuring in an organization, that is basically making the workplace or maybe changing the structure of the organization in a particular, so that the organization operates in a particular manner. It can be called a right sizing. You are actually resizing the workforce and moving departments from here to there, and as a result of that, an employee may find his or her position to be completely untenable or not required in the organization. Then a right sizing occurs. In a downsizing, on the other hand, occurs whereby all the positions that are within the organogram of the organization are required by the employer, but the employer is not able to meet their side of the bargain by payment of salaries, owing to a factor beyond their control. In a recent case, we can talk about COVID, because COVID is an external factor that made it made very many employers completely unable to pay salaries. They required the workforce, they required the positions the employees were occupying, but they were unable to do that as a result of the external factor. So a right sizing can occur at any time in an organization, or we call it a restructuring, can occur at any time in the organization, but it only leads to a redundancy where a particular position has to be declared obsolete, or a particular position is no longer required and therefore has to fall off, so to speak. So if a reorganization or a restructure does not lead to that, then there's no redundancy that is deemed to have occurred in that particular organization. And therefore, the employer does not have to follow the procedures required in law for a redundancy to occur. Now, so in essence, what we are saying is that not every restructuring leads to a redundancy situation. But when an employer intends to downsize the staff or the workforce, then automatically a redundancy has to occur, because by its very nature it seeks to reduce the number or reduce the employees in the organization. Now, redundancy as a form of termination is valid, it is lawful, provided the employer has followed certain procedures that are required in law to undertake the exercise. Now, the first procedure, or the first issue that an employer has to take cognizance of, is the fact that there must be a genuine reason to do or to undertake the redundancy exercise. When I say a genuine reason, it basically means that whatever reason that the employer is fronting as leading them or leading him or her to proceed and undertake the redundancy, it has to be a genuine reason. Because a redundancy can become colorable if it is used specifically to get rid of a particular employee. There are some instances where employers just basically try to use redundancy not in a genuine way, but a way to target a particular employee or to target particular positions to drop off for simply not wanting the employee. A redundancy by its very nature does not target employees. It becomes colorable if you use it to target a particular employee. Redundancy is about positions becoming obsolete or positions dropping off as a result of those particular reasons which are beyond the employer. It does not occur if the employer needs the position and the employer is able to keep that particular position, but the employer does not want the occupier of that particular position. Then that's not a redundancy. Then if you do not want a particular employee in a particular position, then you have no choice but to have a genuine reason and a valid reason for termination of that particular employee and follow the right procedures which are away from redundancy. That is, an employee right now has a security of tenure, so to speak, unless this particular employee acts in a manner that is incompatible with his terms and conditions of service, or does matters which can be classified as gross misconduct, and therefore he can no longer, the employer can no longer maintain or keep him or her in that particular position and has to dismiss. Then a fair procedure is followed. Then that is. But you cannot use a redundancy as a guise to do that. Now, when we look at the redundancy, when you are saying you need to have a valid reason, what are these reasons? Because when you say that I am doing redundancy because I need to right-size the organization in this particular, then you must demonstrate that I was actually doing a right-sizing and I was I was actually doing a right-sizing, and right-sizing situation actually is here, and I can demonstrate that I was actually doing a right-sizing. And remember what we have said, that a right-sizing must not necessarily lead to a redundancy. Therefore, you have to demonstrate that a particular position, as I was doing my right-sizing, a particular position becomes untenable in this organization. And this is how it became untenable, and this is the efforts that I did to actually try to have this employee perhaps maybe relocated to a particular branch or relocated to a particular position, but it became completely impossible to do that, and therefore he had to fall off. So you have to demonstrate the genuineness of the entire process right from the start. And if yours is to do redundancy by way of downsizing, then you have to demonstrate how that particular effect of the economy, or that particular instance, or that particular involuntary act that you are complaining about actually affected you. Because if you say, apart from instances where it becomes noticeable by everybody, COVID came, and all the organization and all the industries and all the employers were affected in one way or another. But even in that particular instance, the effect of the COVID-19 on employers was different. An employer, for example, in the restaurant industry was highly affected, or in the entertainment industry were highly more affected than perhaps maybe other organizations. So how you want to react to this particular stimuli or this particular event that leads to termination, there must be an element of genuineness. To say you at least bring proof to show that as a result of external effects, I am affected in this particular manner, in such a manner that I am not able to settle or to comply with my obligations to pay these employees in time, and I cannot be able to keep this position in this particular manner because of reduced income. And that has to be demonstrated, at least. The standard of demonstration is not standard beyond reasonable doubt, but the standard of proof in this particular matter is at least bring some evidence. Because at the end of it all, this organization is being run by the employers. The employers run this organization. Neither the trade union nor the courts may know may know how perhaps that particular event that you're talking about actually hurt your financial resources, and therefore they are not here to replace you and maybe make decisions for you and say, no, in this particular instance, we know it affected you, but maybe not to that extent. Maybe you ought not to have done this. The court sometimes does not go deeper to be able to analyze if you could have done it completely different, but the court looks at the genuineness of the entire process, that actually this affected you in one way or another and you are genuine in terms of that particular exercise you undertook. Now, once you have established that and you are saying that, look, this is a right sizing exercise and this is how we are likely to have this position and this and this and this fall, or this is a downsizing event and therefore we are likely to have employees across the board fall. Now, what are the procedures that you are supposed to follow when to make sure that actually there's fairness? Because remember, Article 41 of the Constitution demands that in every employment decisions that you make, there must be fairness in all angles and all corners of that particular decision. Now, what are the procedures you're supposed to follow? The procedures are laid out in Section 40 of the Employment Act. There are actually 7-step procedures which can be summarized in this particular manner. Now, once you have created and you have been convinced, or you are convinced that there is a redundancy situation that has arisen, the first thing that you have to do is you have to identify the pool of the employees affected. You have to identify as to whether this affects the entire enterprise and affects employees perhaps maybe in a similar manner, and that always happens in downsizing, where the issue of finances definitely affects the entire, and therefore you have to decide and see which ones should I target, or which department should I target, or am I completely abolishing a particular department? It's very important to identify a pool before you make any particular step, because it actually influences the kind of information that you want to communicate out, either to the employees or to the labor office or even to the trade union. It influences how what are you going to communicate to them, because remember, the law requires you to give a written notification to the labor office, to the employees concerned, to the trade union if the employees are unionized, and in that particular notification you have to give the reasons for the redundancy, the extent of the redundancy that you intend to undertake, and therefore it's very important to understand the magnitude of this from the employer's perspective. And then once you have identified the pool and decide and say these are the pool that are likely to be affected by this particular redundancy, then you proceed and start issuing notifications. Now, the law requires that you issue at least 30 days notification before the effective date of termination, intended date of termination. Now, to the labor office, to the employee concerned, if the employee is not unionized, but if the employee is unionized, then you're supposed to issue that notice to the union. Now, that notice, the contents of that particular notice is defined in law. It has to give reasons for the exercise. You have to explain why you have to undertake that redundancy exercise, and also you have to explain the extent to which this redundancy is going to affect. What are you looking at in terms of the employees you intend to declare redundant? That has to be given. So, where the employee is unionized, the notice is to the union. That is what the law provides, not to the individual employees. Why? It's because this employee has decided to have the trade union represent them in the workplace decisions. Now, the law does not require that this particular trade union, that you must have a recognition agreement with this particular trade union. What the law demands is that there is evidence to show that this trade union has come and recruited employees in the organization, and there are within your workforce employees who are members of a trade union. Because sometimes you see that the employer is aware that employees so and so and so are members of a trade union, but that trade union has not reached a particular threshold to be recognized by the employer, so that they can be able to enter into a collective bargaining agreement with that particular trade union. And therefore, there's a particular tendency by the employers to ignore that particular union when issuing the letters of and instead issue direct letters to the employees who are members and whom have already communicated the fact of membership to the employer. That is wrong. You're supposed to deal with that particular trade union, and it doesn't matter how many trade unions there are, because there are sometimes a situation occurs where two trade unions are recruiting in the workplace, and they have already recruited. None has reached the threshold of being recognized, but you have to involve them in a redundancy exercise involving their members. Now, in a situation where the employee is not a member of a trade union, then the requirement is direct the very letter to the employee personally. The employee is likely to be affected by the redundancy. When we say likely to be affected, it's either the employee is likely to be affected as an individual or a particular department are likely to be, but you have to individually issue those particular notices. Now, what is the effect of these particular notices once you issue them? The effect of this particular notice is to announce that there is a redundancy situation, and you are intending within the 30 days to be able to, you intend to declare redundancies. It is not a termination letter. Remember, the law does not allow, the law has abhorred instant termination of employment contract, whether by dismissal or by redundancy situation. You don't wake up and decide all by yourself and issue a letter of termination to an employee in the guise of redundancy. It basically means that even if you had genuine reasons to declare redundancy, you will have fallen short of procedural steps which are required by law to declare a redundancy. So what you are required to do in that particular instance is to commence the process of consultations with these particular employees and the union. And as I had said, there's a particular notice which you had to issue to the labor office, the area labor office, at least 30 days. So when you're issuing these particular notices, when you're issuing the notice to the labor office, issue the notice to the trade union, and especially for unionized employees, for the employees who are members of a trade union, and also issue individual letters to the employees who are not members of a trade union. What is the effect of issuing these particular letters? The effect of issuing these particular letters is to invite, now commence the process of consultation. You have now told them, we anticipate a redundancy situation. You have now announced to them that there's a redundancy situation and it's likely to affect this particular day, or so and so and so and so and so. So the process of consultation can start, because there's no way somebody can be able to consult with you when they do not know the reasons why you are fronting, you want redundancy, or they do not even know who are targeted. Then that is not a consultation. So once you've given them that notification, and I have said that you don't issue termination, you issue notifications. Notification is different from termination, because a termination letter is a letter I issue to you and I want you out after either immediately or after a period of time. That is a termination letter. A notification basically means that I intend to declare that particular position you are holding redundant, and therefore I'm inviting you so that at least we can be able to work together within the 30 days that the law allows me to issue this notice, to be able to consult, to be able to to discuss together selection criteria that we are using, to be able to look at if there are any other way of avoiding the redundancy exercise that is looking at us. It's like, how do we avoid this particular situation together? Because there's no way you can be able to say, I'm the employer, I am the one who knows how this thing, I'm hiding myself in a corner, I'm the one who knows how to avoid it, and I'm the one who decides who to go and who doesn't, who is not to go. That is not correct. What is correct is involve every stakeholder. Stakeholders here is, as we have said, is the trade union, is the trade union, for the employees who are members of a trade union, is the particular employees concerned who are affected, is the government through the labor office. And the reason for involving the labor office is not mechanical. It's not because you see the law says that I involve the labor office. No, the labor office have a statutory duty. They can be able to advise on what they can be able to advise and assist the employer in terms of undertaking this particular exercise. And therefore, you just don't want to give a labor office what you have decided and what you, so that the labor office has no input. Or you don't want to give a trade union something that you have already prepared, and you are saying, no, you know what, I'm just giving you just to satisfy the mechanics of the law, but I don't intend to hear anybody. I don't intend to say anything. It is me. I am the employer. I am the alpha and the omega. That is not allowed. So now that the notices have been issued, how do you intend to proceed further? Now you tend to proceed further by bringing these people now together in a consultation. Now you have to involve them in a consultation. Remember, consultation is a question of like, I want to hear your side. This is what we are facing in this region. I want to hear your side. I want to consult you so that we can be able to explain to you the reason why I have to take this particular decision. I intend to take. I intend to take. Because remember, you have not made a decision to terminate yet, but you are exploring ways. I intend to do this. Look, this organization is I do not have any other space for you, and all that. That is the effect of consultation. Consultation does not mean agreement, but it means that we are going into this process genuinely. I want to explain to the genuineness of this particular action, the reason why I'm taking this particular action, the reason why you are targeted, and the reason why your position may actually have to fall off. Now, that is if the employee is not unionized. Then you have to have a session with those employees who are likely to be affected. But if the employee is unionized, then you have to involve the trade union in consultations of this. Now, after consultations, then in that particular period, then you also have to involve the affected employees in selection criteria. The selection criteria, the skill, the reliability of that particular employee has to be measured and has to be weighed, especially where you involve or you want to declare in a particular department, for example, there are employees occupying almost similar positions. Maybe there are 10, and you want to declare 3 redundant, and you need 7 to remain. Then you have to apply a very objective selection criteria to be able to identify who is supposed to go and who is supposed not to go. Remember, the redundancy is not occurring because of the fault of these employees. It is not their fault, because if it was the fault of 3 employees, then you go for those 3 employees and dismiss. But that's when I'm saying the whole department has no fault, but I cannot retain 10. I want to retain 7. And I don't want 3. Then you have to apply an objective selection criteria that actually identifies the 3 who are supposed to go. And that's how you can be able to demonstrate and say, I didn't target these 3. These 3 came into my hands as a result of a selection criteria that I applied, which is objective in nature. And therefore nobody can want to say that I set out this redundancy situation to target these 3 employees. Now, but there are instances when you don't have to use a selection criteria, especially where the entire department is supposed to be phased out. I don't have to use a selection criteria to say who remains and who goes, because the entire department goes. Or where the employee is occupying that particular position all by himself, and I intend to declare the position redundant, then I do not have to apply selection criteria, because the entire position is to be phased out. If you are the head of marketing, and that is the position you occupy, and there's only one head of marketing, and I intend to have that position to be clear redundant, I only have to consult you, but I don't have to apply a selection criteria. Now, but you also have to be very careful that when the reason you have preferred or the reason for redundancy is because of cost, then you have to use a criteria which is objective enough to be able to say, why did I take the head of marketing and leave the head of supplies, for example? If, for example, they are all earning the similar amount, and here I want to reduce cost. I think you have to be fair and explain and say, I'm not going to use selection criteria, I'm just going to pick so and so. Then there's a danger that you can be accused of having an ulterior motive and targeting a particular employee to leave, as opposed to having an objective exercise. Now that you have done that, you have proposed out of the selection criteria, you will now come with a list. Having consulted and having used selection criteria, now you'll come with an objective list of the people who are supposed to leave. That list will have been filtered and come into your hands from a very objective process, not from a very subjective process. It's very subjective to start a redundancy process when you already identified and know that so and so and so and so must go, whether they like it or not. Because then what is the essence of consultation? What is the essence of selection criteria? Then you're just putting everybody else through a motion, which can easily be described as a fait accompli, because you already know that this is what I want to do, and instead of dismissing them straight away, I want to create a fictitious redundancy situation with an aim of removing a particular. And that's why sometimes it's so difficult to be able to create a redundancy situation to target and eliminate one employee alone out of, for example, 100 employees. Then that is not a genuine redundancy, because how would an involuntary situation make you target only one employee out of a rest of 100 employees? Because that may not appear genuine. Now that you have done all that, you've done the consultation process, you've done the selection process, and now you have in your hands employees who have fallen in your hands through an objective process, then you'll have no otherwise but to have to let them go. But wait, there's an aspect of redundancy package that they have to. The law requires that before they leave, at the time when you're issuing the termination notices, you have to compute and pay them their redundancy dues. It is wrong in law to have them leave or to terminate their employment and then pay them later, because we know and we understand that you are effecting this particular redundancy because of financial reasons, because you do not have money. But again, you are abhorred, because again the law looks at the rights of both parties. You have a right to create redundancies, but again you don't have a right also to refuse to pay them. Pay the redundancy package. So when we say redundancy package, we mean there are specific payments that are required by law to be made by an employee who has now been declared redundant. The first payment that the law requires under Section 40 of the Employment Act is that you have to pay this employee leave pay. Any pending leave have to be paid in cash, because that is the aspect of termination. The employment contract is being terminated at that particular point, and therefore the employee has no avenue of actually using this particular leave, and therefore you have to pay this, you have to encash this leave. The second payment that the law requires is that for you to declare this employee redundant, or at the point of declaration of the employee redundant, then you must have paid at least 1 month salary in lieu of notice. At least 1 month salary in lieu of notice. That is a requirement. The law requires that you pay that in lieu of notice. Now, when it comes to this payment in lieu of notice, there has been a little bit of controversy as to whether you have an option as an employer to be able to force this employee to serve the notice, or to have an option of serving the notice instead of payment. But I think that the law is very clear that you do the payment. Don't have an option, but to do the payment. The third aspect is you have to pay severance pay. The current rate, the minimum rate, is 15 days pay for each and every completed year of service. So for every 2 years, you pay 1 month salary. Now the law has been very clear, and the courts have been very clear that you have to compute this based on the completed years of service, not on the years remaining to serve or any other parameter that you think is because this is where the employees who have been or who have invested in the organization for many years will definitely have more pay than employees who have not invested in the organization. Severance pay is payable strictly to employees who have been declared redundant and is distinct from service pay. It is not an equivalent or it is not a substitute to service pay. Severance pay is strictly to employees who have been declared redundant, so that if an employee has not been declared redundant, that employee does not merit severance pay. Now, you also at this particular time have to pay all the contractual dues that are payable to this particular exiting employee at the point of exit, even though it is not provided for specifically at Section 40 of the Employment Act. But what is clear is this particular employee is exiting the enterprise at this particular moment. So it basically means that if there's any accrued payments which already had accrued to this particular employee, if there was any accrued but unpaid bonus, if there was any accrued and unpaid salary, or any other benefit that was payable, then this is the Waterloo moment that the employer has to pay all those dues. Those will all, the redundancy dues and all those particular dues which are payable will now all together form the terminal dues payable to this particular employee. So this is required to be paid at the point of exit, so that at the point of exit, the employee does not have to again call back and ask when are my payments due, because you have to settle them at the point of exit. So if these procedures are used and followed properly, then redundancy becomes a viable mode to terminate the services of an employee where there exists genuine involuntary actions that make it completely impossible for an employer to retain and maintain employees in an organization. Thank you very much.